Good morning, Ryan.
Good morning, Andrew.
So I'm Andrew Weissmann, as probably people who are following this know, and I'm with Ryan Goodman. We both teach at NYU Law School, and we wanted to talk to you this morning about a new document that came out yesterday. I actually was able to talk about it on Lawrence O'Donnell. That's one of the nice things about live television, and also Lawrence being so good and having a very nimble team, as we were able to sort of look at it, read it, and then quickly talk about it. But
Mm.
there's no substitute for what we're about to do, which is to have a much longer conversation to get people up to speed on what the document says, what its import will be in terms of the immigration cases that are currently being litigated all over the country, up to and including the Supreme Court of the United States, and what we think the import will be. Sort of that's our speculating about, and sort of, I would say, educated speculation about sort of what we think the courts will do, what we think the government's going to argue based on this. But why don't we start, Ryan, by talking about what is the document? Like, what is it that the document actually is? Like, who wrote it? And then we'll get to sort of what it substantively says.
Great. So the document itself is a U.S. intelligence community product from the National Intelligence Council. And they are reviewing the question that is at the heart of the president's reported invocation of the Alien Enemies Act, which is what exactly is the relationship between the Venezuelan government under Maduro and the Venezuelan gang, Tren de Aragua TDA. And 2 points about the document that I think are worth mentioning. First, it's just the bottom line up front. So the bottom line up front is the document contradicts all sorts of statements, including statements written into the presidential proclamation itself, because the document comes to the pretty strong conclusion in the way in which one reads these kinds of materials by saying there is no connection, that Maduro is not directing the TDA. And in fact, the TDA is battling in sometimes fierce gun battles with the Venezuelan government. So that it's just the idea that the TDA is being directed by Maduro is a fiction. And we can talk about why that fiction was necessary to create as a pretext the invocation of the Alien Enemies Act. So I'll read the the most important quote, I think, from the document. So the document.
Stop you for a second, Ryan, before this is not to be like a teaser for our audience, but I just wanted, before we get to that, I just wanted to make sure people understood that the National Intelligence Council is part of the DNI. That's the Director of National Intelligence. So this is a product of the agency that was created after 9/11. Its head right now is Tulsi Gabbard. And so there is a Trump appointed and approved, Senate confirmed head of the DNI. And the date of the document, I think, is important. This is not a sort of Biden administration document in terms of its timing. The date of it is, it's dated on its face April 7th, 2025. So this is a new product. When you were saying it's a product of the intelligence community, it is coming from the DNI, headed by Tulsi Gabbard. And that is, I don't do math in public, but that is barely a month old, assessing this critical issue of the relationship of the gang, the TDA gang, to the Venezuelan government. And this was released by the DNI on May 5th. So less than a month after it was created, it is now publicly available. And then just one quick backdrop to why people care. Like why is the relationship of the TDA to the Venezuelan government something that is even remotely relevant? Why is this something that the administration had to focus on? And without getting into the gory details of the precise language, in order to invoke the Alien Enemies Act as a way to seize, extract, and remove from this country the plane loads of people under the Alien Enemies Act, as opposed to just doing the normal immigration route where people get due process and there's hearings and you have to prove up your case, and the other side, the immigrant gets a chance to be heard. Under the Alien Enemies Act, you need to be either at war with the foreign government, and people are part of that foreign government who you're trying to remove, or there has to be an invasion by that foreign government and or a group acting on behalf of that foreign government. In other words, the foreign government can have operatives, but you have to have that link to a foreign government. And so the proclamation, Ryan, that you were talking about, that President Trump issued, was providing that link, saying we are trying to extract people in the TDA, and the reason we can do it under the Alien Enemies Act is because that group, that gang, is a sort of de facto operative of the Venezuelan government. So they needed that linkage because that's what the statute requires, that be the case. We'll get into sort of the court cases about that, which has dealt with sort of the legal issues and factual issues that come up. But the proclamation saying, oh, there is this linkage. The TDA is invading our country on behalf of, and as part of, and as de facto sort of proxy for the Maduro government in Venezuela. So that's the backdrop. And so now now having sort of prevented you from giving the bottom line up front, what does the document say that you found particularly relevant?
Sure. And the language usually used from the proclamation and in the government's briefs is that the TDA is directed by Maduro and that they're acting in concert together. So here's the juiciest line, most important line out of the document. Quote, the Maduro regime probably does not have a policy of cooperating with TDA and is not directing TDA movement to and operations in the United States, end quote. And then it goes on to substantiate that. The document itself is essentially 5 pages. That goes on for some reason to a 6th page, but there's nothing really on the 6th page. So it's a 5-page document, which these documents are usually of that length. And then it has bullets underneath that proposition articulating, excuse me, some of the things that I'd mentioned, which are the fact that the Venezuelan government forces are essentially in battle with TDA and the like, and that there's only one somewhat dissenting view in the intelligence community, because this is an intelligence community-wide assessment, and that's from the FBI. But when it boils down to it, the FBI is not saying that much different from the prevailing view.
Yeah, so I wanted to sort of tease that out a little bit. So when you read the full document, it is clear that the intelligence community assessment with that one FBI dissent that I'm going to come back to in a moment, the key language that to reiterate it is that they conclude that the government is not directing TDA movement to and operations in the United States. So that if that is the state of the record, that is contrary to the presidential proclamation and contrary to what is being said in court by the Department of Justice attorneys defending what is going on and saying why they can invoke the Alien Enemies Act. And there's a lot of flavor in this document about that there's sort of an uneasy relationship between the government and the TDA. And you really get the sense that there are these gangs that are very powerful. And while there's efforts to sort of try to control them, there's a sort of toleration of them because of how powerful they are. And that at times there's friction, at times there's just sort of acquiescence to what they're doing because they don't have the power to actually eradicate them. And it sort of goes through that. It also says, with respect to the FBI assessment, which is noted, and that's typical in an IC product, intelligence community product, where not all agencies will be uniform, and they note dissenting views or even slight dissenting views. Um, that it doesn't make sense to the IC that there even logically would be that direction, because they say the TDA is pretty diffuse as an organization, and then they take on the issue that the FBI dissents on. The FBI says, well, we actually think there may be some government officials who are working with the TDA. In other words, what you really feel is that the FBI is saying, well, there's some corrupt, Venezuelan actors who the TDA has paid off, and are working with them, but you don't get the sense that what the FBI is saying, and thus we conclude that the TDA is acting on behalf of the government for the purposes of invading the United States. So you don't, even though there is this dissenting view from the FBI, it's not sort of on the critical issue of, does the government, is it really controlling the TDA in toto? But more so, even more important, it doesn't say that it's controlling them for the purposes of an invasion of the United States. So I think that's important, because when you and I have been talking about this, we've been thinking about what would the president and the government have to argue now. And, they could try to latch on to the fact that the intelligence community was not uniform in this document, that there is some dissenting view. Let's leave aside for one moment the irony that the president would be latching on to the FBI's view, an agency that it traditionally, he says, can't be trusted. And so he would be trying to now grab onto it because it would be closer to his view. But I want to make sure people understand that it doesn't actually say that even the FBI description, at least in this document, is not one-to-one with what the president would need it to say, which is that it is conducting this invasion of the United States on behalf of the Venezuelan government, as opposed to some officials facilitating migration to the United States, and as opposed to trying to have this sort of invasion. But that is, to me, what we don't know the full scope of what the FBI actually said internally. We just have this short description in this document. That, to me, is where the president is going to have to go. Is he's going to have to say two things. One, that there is information in here, and there may be underlying documents that are closer to his view. And two, the president, can make his own judgment after looking at all of this. And he doesn't have to take the views of the intelligence community as gospel if there is some other, logical view or fact-based view. And the court's review of it should be either non-existent or extremely deferential to that position. Obviously, what would help him is any sort of factual support for the factual proclamation. I mean, this is very much like there's fraud in the election. I mean, you can say that, but the courts are going to be asking, to some extent, or I should say, some courts will be asking, is there any proof at all to suggest that that's the case? And obviously, there's some judges will say, we don't look at that. We shouldn't have the power to look at that at all. I think other judges might say there has to be at least some um, sort of facial validity to what you are doing before we're going to give you that deference. So, what's your take on that? We're sort of getting
Yeah,
to sort of like the import of this. How do you think the administration will try to get out of this predicament, and how the courts might respond to that?
sure. And then let me just say two other pieces about the document itself, but one of them specifically in response to what you just asked. But one other piece for the document, some folks might have familiarity with how the intelligence community will make certain kinds of assessments, and they'll do them on make assessments on different gradations, so like low, moderate, or high confidence. And I thought there was some other language in this document that was unusually of high confidence, in a sense. They didn't say those words, and sometimes they'll just use those exact words. But the underlying factual predicate for their bottom line up front kind of conclusion, I thought was very strong language. So I'll just read a couple of those lines. They say, Venezuelan intelligence, military, and police services view TDA as a security threat and operate against it in ways that make it, and here's the key words, highly unlikely the two sides would cooperate in a strategic or consistent way. So that was one important one. And then a second one was the IC has not observed the regime directing TDA, including to push migrants to the United States, which probably would require extensive coordination and funding between regime entities and TDA leaders that we would collect, meaning collect on, they would find that information. So we've seen nothing,
And we know
nothing, and you
that
would
was
uh,
happening.
have to
We would
assume that
know.
there's an
Yeah.
extensive coordination. So that's one. So that's what the government and the president and the DOJ are now contending with, because this is now a public document. It's being declassified. I think trying to latch onto the FBI assessment is one direction for them to go, and I'm sure they're thinking about that, but it's super hard in a couple of different ways. One, if you just did a copy and place, cut and replace words in the DOJ's statements to the courts as of today, versus cut and paste in the FBI's assessment, it doesn't fly. It just doesn't work. I mean, for those documents to say, oh, and this proclamation is based on the fact that some Venezuelan officials are supportive of the TDA also because they get kickbacks. It's like that is not the TDA operating as a foreign government because they're acting at the direction of Maduro. It's just it's the two don't it doesn't match. And one other somewhat finer point on it. Um, I've been thinking at Just Security that it would be great to get an international law expert who could write up the analysis of what does international law even say as to when a non-state actor is um, operating in such a way that all their actions are attributable to the foreign government. So they operate as the de facto organ of the foreign government. There are specific tests for that. Attribution rules. I should be careful exactly what I say because my law students are currently taking an exam which has questions related to that on it because we study this very closely. The tests of attribution are already very difficult to meet based on the existing record that the DOJ had created before the courts. With this document, and if you took the FBI assessment, it doesn't get you anywhere close to it. It doesn't come within reach of the tests for making that determination. So I think
So
that's
Ryan,
another piece.
so Ryan, are you saying that the people listening to this are going to be able to take your exam and do very well?
One way or the other.
Yeah. So I wanted to read before we get to sort of how you think the courts might respond to this. I sort of gave you my view that there's going to be it's really going to depend on the courts. Different judges have different views about the level of deference and how much they can sort of look under the hood. If there is some factual support, and we can then talk about the Texas judge's view of just the proclamation itself on that issue. But I wanted to just read for people the critical line about the FBI in the report, so people have that and understand, what it is that the Trump administration will at least will try to do. And I do think, there is some data that we're missing, which is what is the underlying intelligence report from the Bureau on this issue. But here's the key description in the document, and it is this. While FBI analysts agree with the above assessment, that's really critical. In other words, everything that we're talking about in terms of the IC um, and its assessment of the TDA versus the Venezuelan government. Um, it says the FBI analysts agree with that. So that's not disagree, that's agree, but there is a nuance. And it goes on to say, while FBI analysts agree with the above assessment, they assess some, and that's italicized, some Venezuelan government officials facilitate TDA members' migration from Venezuela to the United States and use members as proxies in and then a series of countries, but including the United States, to advance what they see as the Maduro regime's goal of destabilizing governments and undermining public safety in these countries, based on DHS and FBI reporting as of February 2024. So again, one thing of note is the president's going to latch on to both DHS and FBI reporting under the Biden administration.
Mm.
So, I mean, obviously, logical consistency is not his strong suit. So I'm not saying that that's going to cause him even a speed bump. Um, but that's the language that I think is the sort of the language that the administration is going to have to try to use. I agree with you that it doesn't map to the exactly what's said in court. But again, that is, Ryan, you're operating on the consistency rules that seemed to govern about a minute ago when that's something that we all thought was important and cared that our government was taking consistent positions and not flip-flopping. So I think that's what we're going to see is that flip-flopping, and we've obviously seen it before. And that's, just to be clear, that's not flip-flopping from one administration to another. That's normal. Where a new administration can say we're taking a different view of what the law requires, or we have a different assessment of how we read the facts. This is a change within the administration based on now public information that seems very much to contradict what they have been telling the courts.
Yeah. Um, and I think the courts are going to have to deal with two questions in a sense. One is the question you first posed, which is if the administration comes forward to say, look, we still have a sufficient basis for invocation of the Alien Enemies Act, and it's the FBI assessment, and you've got to give great deference to the president gets to choose, especially when there's a split within the intelligence community. There's that argument. And I think, and then the second argument is, I assume the courts are going to have to grapple with, and the plaintiffs are going to bring it to their attention, that there's contradictions in what they've said in the past. The ways in which they've said that statements that are not supported by the FBI assessment and are contradicted by the intelligence community's assessment, statements about the idea that uh, the TDA is being directed by Maduro and the like, and that they're in concert with each other as a hybrid regime and all sorts of things like that in the government in documents that they've submitted to courts. I think both of those things are gonna hit in the courts momentarily. I can imagine that some plaintiffs might even submit certain filings today on the basis of this report. On the first one, I also am trying to think through and anticipate how the courts might respond. Generally, the courts might say, for example, that there's a complete political question here. This is not within our domain. We can't really make these assessments of the intelligence community documents. That's a presidential determination. Or they don't say it's totally out of our domain, but they give great deference, as you just described, Andrew. On the other hand, that's in a normal circumstance in which they do not actually have the declassified document. And this isn't a leaked document. This is an officially declassified document that's a part of the record. And I think that therefore the burden might shift, or the way in which they'll assess it would be just more realistic. It's staring them in the face. This is just a fraud. In
And
terms
that's where I think that the administration's overreach and
Mm,
unreliability is going to really brush up on the what in the law is viewed as the presumption of regularity that exists when the government takes action. There's sort of a strong presumption, unless the person who's challenging it can show that there's something wrong that's happening. And just so people understand, the political question doctrine that has come, that Ryan, you alluded to, is very much saying if this is a political question, it's a matter of policy, then the courts back off and say that's not, we don't engage in that. We deal with, like, is something unconstitutional? Is it a violation of the statute? Is there a factual issue? But there's something called a political question doctrine where, again, this is sort of at a 60,000 foot level where the courts say we defer. Where that came up is in a case in Texas. It was the first case that reached the merits of whether the Trump administration validly invoked the Alien Enemies Act. And it was looking at the statute that the Alien Enemies Act itself, and it compared what was required under the statute, where there has to be, as we talked about at the beginning, a war or invasion that was going on, and then obviously that the person at issue is part of that group. But here the court looked at what does the statute require, and what did the president say in his proclamation, and just looked at those two things and said they do not map onto each other. The court over and over again, I believe on page 18, talked about, this could just be a political question. We're not dealing with a situation where the court has validly invoked and said all the right things and is invoking the Alien Enemies Act, because that would be beyond the expertise and the province of the court. But the court went on to say the problem here is that the proclamation, in fact, doesn't make the findings that are necessary to have the Alien Enemies Act invoked, and so strikes it down. In some ways, it's a very limited decision because I sort of read it in some ways as a roadmap for how the administration could rewrite the proclamation, assuming that you didn't care about the facts, or to be generous. You could imagine another situation where they just sort of messed up how they did it, and they do have a factual basis. Here, I think that if the administration tries to revise the proclamation to deal with the fact that it did not say all the things that it needs to say to trigger the proper invocation of the Alien Enemies Act, to your point, I think there could be just a lot of skepticism on the part of the court, because it's not only just the second attempt, but the second attempt of correcting it will fly in the face of the factual determinations that they can see the intelligence community made about what's going on. And so you would think a normal response would be, do you give me some factual predicate? In other words, it cannot be that the political question doctrine allows you, like, what if I had a taped conversation where you said, I'm lying, I'm going to make this up, but we're going to put it in the proclamation and we're going to give it to the court. Does the political question doctrine and deference in that situation mean that the court says, well, that's what they said? It just can't be the case. And by the way, I'm sure a lot of people listening to this are thinking, this is the problem with the courts and the legal doctrines. But I think I want to make sure people understand the discussion we're having is about the courts is precisely because the courts do defer on policies issues to the executive branch. All the things that the courts are being attacked on by the administration saying, oh, look, unelected judges are preventing me from doing things. No. The discussion we're having is that these very strong doctrines exist in the courts precisely so that they don't tread on the proper province of the executive branch. And we're raising the issue of that there has to be room for the courts to say, no, that you can't just make it up and then say, we are going to defer to that. And I think that's where the track record of the 100+ days and the defiance of the the courts and the lack of credibility in terms of over and over again either factual misrepresentations or positions that are just unconstitutional really could come back to hurt them.
Yeah. And couple thoughts on that. One is that just so people understand the opinion that you're describing in the district court in Southern District of Texas by Judge Rodriguez, his interpretation is already a very expansive interpretation that's hugely deferential to the president and the executive branch. So much so that I think going up, if it went up on that basis and that had to be determined by the Supreme Court, they wouldn't I think, not address it. They wouldn't respect it because it also flies in the face of certain Supreme Court jurisprudence that even says recognition of foreign governments is not purely a political question, and courts can review it. And here we have an additional situation in which I think courts also operate in a reality. The reality is public legitimacy and the like. Everybody now knows what's going on. So it's very hard to say, yes, I'm just going to give complete deference to whatever they put down in paper, even though they themselves have declassified a document that says no, that the sky is in fact blue, and even though they're writing in the paper the sky is green. So I
And
think,
to me, Ryan, I think it in many ways, you and I have taught the so-called Muslim ban, which was the sort of big first test in the Trump 1.0 administration, where the so-called Muslim ban went through various iterations before it sort of got to its final resting place. Then it went up to the Supreme Court, and they said it was legal. I mean, there were dissenting justices, but I feel like this is going to be a test of the court to see where they are now on a similar type of issue, because there, not a single justice justified the horrendous record of xenophobia and discriminatory statements made by candidate Trump about the Muslim ban, and instead tried to say, you know what, we're not going to look at reality. We're going to sort of leave aside what we know he has said and just decide that this is something that on its face and with there was some factual support for it, say that any other president could do this. And so there was a sort of unreality to that, which is like, you know what, we're going to kind of ignore the factual context and just look at this is something that any other president might have been able to do. I don't know that that kind of approach is going to fly now, in part because I don't think any other president would do this or frankly could do it. And I also think that the blinking at reality, I'm not sure you're going to get the same the same five justices to go along with that. I mean, we shall see. But this issue of the sort of the whether the Alien Enemies Act is lawfully invoked here with respect to the TDA is
right.
one that I think is certainly going to go to the Supreme Court. We already have before the Supreme Court, there's a stay in place with respect to people in Texas as to whom it is being invoked. And there'll be issues about the due process that they're entitled to. But this issue of whether the Alien Enemies Act can even be properly invoked will end up, I think, in the Supreme Court. One final thing I just want to make sure people are aware of is that in a case where a husband and wife were able to have a hearing where the government said, oh, they're part of a gang and they can be removed. So they actually had the due process hearing. There was an ability to challenge this. The court looked at the evidence and said, I mean, this almost said the following: "You've got to be kidding." And they said, "You don't have it. It's not there. It doesn't even meet the civil standard of a sort of preponderance here. This is double or even triple hearsay." and threw it out. And that is an example of that we've got so many issues here, and it's why due process is so necessary, because now we're dealing with a document that says it's not clear that the factual basis and predicate for linking this gang to the Venezuelan government exists. And two, the government, when it finally had to sort of put up or shut up on the with respect to, is the individual who's in front of the court, is that person part of a gang that could even be, it could apply to? In other words, it's one thing to say this law can be properly invoked, but then the question is, can it be invoked as to Ryan Goodman? Why is he part of the TDA? And the courts, when it came to that, said you don't have it. So that's a really good example of why I think that the courts will be, or should be, at the very least I can say should be, highly skeptical of the government's claims here, because when it actually had the opportunity to prove up the facts, and that's where I won't say shocked, but it's like, you would assume that you're seizing somebody, extracting them from this country. And by the way, it's not like you then remove them and they are free as a bird in a foreign country. You're then sticking them in a jail for what could be the rest of their life. And the idea that you don't have it, that you don't, like, you might have screwed up on the application of the law, but you don't even have the factual predicate that Ryan Goodman is in that gang, is unbelievable. I mean, under that theory, I mean, that's, you could just scoop up anybody, and then they're denying due process to those people. And then once they're in that foreign country, they're saying we don't even have the ability to bring you back.
Yeah, and a couple other cases that are very similar like that are Abrego Garcia. Admittedly, that's an MS-13 allegation, not Alien Enemies Act invocation under with the TDA, but there, the district court judge Policini says that the government's presented no evidence that he is an MS-13 member. And even though they say that publicly, Trump officials say publicly he is one, and they say he's a criminal MS-13 member. That's one. The other, the JOP case, Stephanie Gallagher, a Trump appointee judge, has said in that instance the alleged TDA member, the government presented no evidence. That's her words. And she says this court is a court of evidence. Just to emphasize, like, you have to give us something here if you're going to claim in this instance that this person was a public safety threat. That's why they were uh, removed under the Alien Enemies Act. The other piece I think that might be on people's minds, and I want to also address, is somewhat the chronology, especially when we mentioned, the date of the document that we're talking about today is April 7th. So people might think, well, wait, hold on a sec. Maybe that's a late in time assessment. And only subsequent to April 7th would it really register as to whether or not the government is misrepresenting the underlying intelligence. And I just want to give the chronology that addresses that. So, according to the New York Times, Charlie Savage's reporting and others, the government makes its initial assessment February 26th, the intelligence community, with the FBI having their difference. February 26th, that's according to the New York Times. And then on March 14th, 15th, the president invokes the Alien Enemies Act with the propositions that flatly contradict what the intelligence community has said. Signs it on the 14th, publicly releases on the 15th. That's one. Then the New York Times reports on March 20th what happened in February 26th, that the intelligence community actually contradicts the underlying propositions of the proclamation on the Alien Enemies Act. And subsequent to the New York Times reporting, they still repeat the statements the DOJ does in court. I have an April 1st document from them. Then we have the April 7th document we're talking about today from the National Intelligence Council. And on April 23rd, in the case that we were just talking about, Southern District of Texas, where the judge, a Trump appointee, reaches a final conclusion on the merits and says, you can't invoke the Alien Enemies Act, it's unlawful. the government submitted a brief before him on April 23rd, repeating the same lines about that the TDA is acting at the direction of Maduro. April 23rd, after the April 7th National Intelligence Council report. So that's just to underscore how invested the DOJ has been in this, and how contradictory it is with the underlying intelligence. And then one last piece on it as well. The New York Times last night with Charlie Savage reported out this document and also noted a couple public statements by the Attorney General Bondi and by Todd Blanche, her deputy, in which Blanche, first of all, said, "Oh, no, the New York Times piece is inaccurate." And she herself also went out on TV and said
Yeah.
similar things. So,
Can I just put a
yeah.
fine point on that, which is I want to make sure people understand that this is sort of a separate point. The chronology is incredibly useful, but when the Times reported this, and it was not yet public, the Department of Justice, through its two highest level people, said that's wrong. That's not true. That it was not wrong. It was right. So it's not just that there has been sort of misrepresentations to the court, but the New York Times got it right, and we now have, by all appearances, the Attorney General and the Deputy Attorney General getting caught with their hand in the cookie jar, sitting there going, "Oh no, that's not what happened. That's wrong. That reporting is wrong," and the Times has been proved right. So that attack on the media is like it's like chef's kiss to what is going on here, in terms of part of that disinformation campaign, that on this issue. Ryan, there obviously is much more that people should be focused on now, because, as you said, this will not be raised in court. It could be as soon as today that people are going to be focusing on this, and the government's going to have to be scrambling. So, everyone, thank you very much for listening. I know this was rather long, but I think it's going to have hopefully pay dividends, because you're going to see this play out in the lower courts and maybe all the way up to the Supreme Court, and this document becoming really central to it. So stay tuned. To both of us are on Substack. We're both on YouTube. I'm going to give a big shout out to Just Security, that we both are involved in, you in a much more serious way than I am, as its co-editor in chief. So thanks so much for this discussion.
Thank you. It was great.